Good morning and welcome to Gough Square Live. I'm Sabrina Goodchild and today I'm joined by Jack Brady for his very first Gough Square Live, having joined Chambers as a tenant in the autumn. So welcome, Jack. Today we're going to be talking about further updates from the Competition and Markets Authority, updates which are coming in thick and fast in advance of April, when the likely most relevant parts of the Digital Markets, Competition and Consumers Act 2024 to those watching, otherwise known as the DMCC, are due to come into force. If you haven't done so already, do check out Chambers' two previous recordings on the DMCC, one of which provides a high-level overview of the changes, and the other that provides more of a deep dive into the new civil penalty regime. Both can be found on the Gough Square Live YouTube channel. Today, Jack and I will be looking at two CMA consultations, both of which close in late January. The first is on the draft guidance on the protection from unfair trading provisions in the DMCC, so the replacement CPUT provisions. Whilst limited to providing the CMA's view on the new unfair trading provisions, once finalised, it's likely to be a useful tool to those enforcing and advising on those provisions. For those familiar with the CMA's unfair contract terms guidance, which was published after the Consumer Rights Act came into force in 2015, it's a very similar document and hoped to be similarly useful. So Jack will be providing us with an update on that. And I will be providing a whistle-stop tour through the CMA's draft enforcement guidance, which, when viewed alongside the CMA's draft annual plan, provides some insight into the CMA's expected actions in 2025-2026, and how their new expanded roles will sit alongside other enforcers, such as trading standards. So Jack, do you want to kick us off?
I would love to. On the 11th of December 2024, the CMA published its draft guidance on the protection from unfair trading provisions in Part 4 of the DMCC Act. Those provisions replace the Consumer Protection from Unfair Trading Regulations 2008, and they're expected to come into force on the 6th of April 2025. The DMCC Act gives the CMA direct enforcement powers in relation to unfair commercial practices, and the CMA says it will have regards to the guidance when exercising those powers. So, in addition to being a useful document for the CMA, the draft guidance is helpful to other enforcement bodies, including trading standards teams, who will be versed in the enforcement of CPUT offences, but are looking ahead now to enforcement under the DMCC Act, and traders and those advising them who may wish to consider the draft guidance to comply with the protection from unfair trading provisions in the Act. The CMA's consultation on its draft guidance closed on the 22nd of January. Views were sought in response to 5 questions relating to the clarity and usefulness of the guidance, particularly the guidance relating to drip pricing and fake reviews. In brief overview, the draft guidance is split into 4 parts. Part 1 is an introduction to and overview of the scope of the provisions relating to unfair commercial practices. Parts 2 and 3 relate to prohibited commercial practices. And Part 4 outlines when unfair commercial practices amount to criminal offences and the applicable defences, penalties and time limits. Now, the guidance runs to over 100 pages, so in an effort to keep things engaging and in the interest of time, I'll pick up on just a few interesting points in each part of the guidance. So Part 1. Well, Part 1 of the guidance features a helpful refresher on the key provisions relating to unfair commercial practices, the UCP provisions, which are neatly depicted by the diagram shown on the slide. In short, some practices are only unfair if they are likely to cause consumers to take a different transactional decision. Other practices are prohibited regardless of their impact on consumers' transactional decisions. Those include the practice specified in Schedule 20 to the DMCC. Generally, traders can expect the same or similar requirements and prohibitions to apply to their commercial practices after the UCP provisions come into force, as currently apply under the CPUT regulations. The majority of the provisions in the CPUT regulations are actually maintained in the Act. To that end, the draft guidance is similar to the guidance published on CPUT by the Office of Fair Trading, which may already be familiar to those listening. Part 1 goes on to helpfully define with examples a number of key terms, including commercial practices, product, consumer, trader, the average consumer, which is a necessary reference point when assessing whether a commercial practice breaches the requirements of professional diligence, or the prohibitions of misleading and aggressive practices, and of course, transactional decisions. Of particular use are examples of commercial practices that relate to the acts or omission by a trader when promoting or supplying a product, where a trader might not be selling or promoting themselves. One example is a trader's supply of waterproof clothing to retailers that market themselves to consumers as suppliers of eco-friendly fashion. Any claims relating to the ultimate promotional supply of the product, the clothing is made of a certain percentage of recycled material, for example, must be true and accurate, even though the trader doesn't sell directly to consumers. Examples demonstrating where a consumer is acting for purposes that are wholly or mainly outside their businesses and where they are not are also useful. For example, an individual who occasionally sells unwanted clothes on an online marketplace is likely to be a consumer, but a sole trader who buys a printer to use largely for business purposes at home is unlikely to be a consumer when buying the printer. Also useful guidance on approaching identifiers of vulnerability, including age, mental or physical health, and credulity when assessing whether a consumer is vulnerable to a commercial practice or the selling or promotion of a particular product. The draft guidance particularly emphasises that vulnerability can be context dependent and may arise as a result of other than those factors. For example, advertising of training opportunities for people who've recently been made redundant is likely to be assessed from the perspective of a consumer who is vulnerable because of the circumstances of having lost their job. At the end of part 1 is the flowchart shown on the screen, which those listening may find useful when approaching an assessment of whether a commercial practice is unfair. That's for part 2. The start of part 2, at that point, guidance is given on the general prohibition on unfair commercial practices, which is a prohibition on practices that contravene the requirements of professional diligence, the conduct itself, and are likely to cause an average consumer to take a different decision. So that relates to the effect of that conduct. Particular guidance is then given on misleading actions, misleading omissions, and aggressive practices, which all amount to an infringement of the UCP provisions if the average consumer is likely to take a different decision. I would draw your attention to the following points in part 2. The draft guidance on extending the scope of a misleading action from a commercial practice that contains false information to the provision of false or misleading information. For example, a trader tries to sell a consumer a premium package for an online television streaming service. The consumer is misled by the information provided to believe all channels are included in the subscription, but some key channels are only available at extra cost. The non-exhaustive list of the types of matters in relation to which traders should provide clear and accurate information that is contained in the draft guidance is also spoken about in part 2. Well, this is particularly helpful because unlike in the CPUT regulations, the UCP provisions do not expressly set out the types of information relevant to a transactional decision. Also, the removal of the requirement in CPUT for all of the features and circumstances of the commercial practice to be assessed when considering whether a commercial practice involves a misleading omission. And finally, part 2 comments on the simplifying of the test in relation to aggressive practices, such that it need only be shown that a commercial practice uses harassment, coercion, or undue influence, rather than that it significantly impairs or is likely to significantly impair the average consumer's freedom of choice in relation to a product. As for part 3 of the draft guidance relates to commercial practices that are prohibited regardless of their impact on the average consumer's transactional decisions. I noted particularly the guidance on the omission of material information from an invitation to purchase, which falls into that category of prohibited practices. As a reminder, an invitation to purchase is a practice involving the provision of key information about a product's characteristics that enables a consumer to decide whether to buy it or not. Under CPUT, any assessment of whether a commercial practice involved an omission of material information when there is an invitation to purchase would engage the transactional decision test, i.e. whether the practice actually causes or is likely to cause the average consumer to take a transaction decision they otherwise would not have taken. The draft guidance to the DMCC Act makes clear that that test has now been disposed with. It is now necessary to identify only whether material information has been omitted from an invitation to purchase, which can exist before a consumer makes a decision to purchase a product, or even before it's possible to purchase a product. Under the DMCC, traders are obliged to indicate to a consumer in an invitation to purchase the total price of the product. This is the prohibition of drip pricing. But when are charges mandatory versus optional? What to do if it's impossible to calculate the total price? And how must material pricing information be presented? Well, the answers to these questions can be found in the draft guidance. Finally, we're almost there. Part 4. In Part 4, you will find guidance, the unfair commercial practice amounting to criminal offences, and the applicable defences, penalties and time limits for prosecuting those offences. This part of the draft guidance is fairly self-explanatory, but a particular note are that the omission of information from an invitation to purchase is a standalone offence, while the new banned practice in relation to fake reviews is excluded from the list of criminally enforceable offences. At the end of the guidance, there's an Annex A. It includes illustrative examples to show how the UCP provisions might be applied in practice. And Annex B, which gives particular guidance on the prohibition of fake reviews and contains this useful flowchart on the banned practices relating to fake reviews, concealed incentivised reviews, for example, where submitting a review about a product without disclosing a commercial relationship with a trader, and consumer review information. That is false or misleading, or that it's published in a misleading way. For those familiar with CPID, your reward for staying tuned in until now is a note on the most useful tool the draft guidance has to offer. The table, a section of which is shown on the side, comparing the unfair commercial practices provisions of the DMCC with those in CPID and describing the changes in short notes at the end of the guidance. Now that is a brief canter through the CMA's draft guidance on unfair commercial practices. As I said earlier, the consultation was open until the 22nd of January. Clearly the CMA's final guidance may change, and if it does, I'm sure it will have done so on the back of your brilliant contributions. Now over to Sabrina.
Thanks very much, Jack. So now let's turn to the CMA's draft guidance entitled Consumer Protection Enforcement Guidance. Now, the majority of this 62-page document summarises the powers available to the CMA to deal with consumer law breaches, both in terms of investigation and also enforcement, a summary of which you should be able to see on the slide. So with the exception of 2 key points, which I'm going to look at in a little more detail in a moment, if you're familiar with the DMCC and the Consumer Rights Act, you're unlikely to need to review the document in any great detail. But if not, it's a very great high-level summary. But when viewed alongside the CMA's draft annual plan, we can get some indication of the direction of travel by the CMA. So what does this annual plan say about consumer protection? Well, as is to be expected, firstly, there's a marked emphasis on broadening the CMA's consumer protection work, which is best highlighted, I think, by the following passage. The guidance provides, this year represents a watershed moment for the CMA's ability to tackle rip-offs, misleading sales practices and unfair terms, as we begin to leverage enhanced consumer enforcement powers under the DMCC. For the first time, our enforcement of consumer law and competition law will stand on equal footing, with a clear signal to businesses that they should treat them with equal importance. We are prepared to take even more direct and decisive action to protect UK consumers with commensurate benefits in terms of growth and prosperity across the whole economy. Fighting talk! And secondly, we get an express indication of the CMA's areas of focus. These include a commitment to act in areas such as drip and dynamic pricing, and of course we already know about the open OASIS investigation. But also highlighted are the broad categories of travel, housing, online entertainment, and areas where the CMA has previously set expectations, such as unregulated legal services and trader recommendation sites. And whilst we're on that topic, do keep an eye out for Jack's summary of the CMA's recent publication on improving trader recommendation platforms. There's also a commitment by the CMA to complete its market investigation into veterinary services. And finally, there's a focus on prioritising areas of essential spend to help people struggling with pressure on household budgets. all very topical areas of concern to a broad spectrum of consumers. So it's in that context that the CMA's draft enforcement guidance should be read. I mentioned earlier that there were two key learnings that can be extracted from the draft enforcement guidance. The first is the CMA's general approach to enforcement, and the second is concurrency, i.e. how do the CMA's new powers sit alongside other enforcers which have historically taken primacy in terms of consumer protection. Dealing first then with the general approach to enforcement. As is to be expected, the CMA have said that they will consider a range of factors when prioritising their enforcement action. These factors are to include the likely impact of CMA intervention, the strategic significance of intervention, the likelihood of a successful outcome, and also resource implications. There's clearly an emphasis throughout the guidance on the CMA seeking to deliver high-impact results by changing market behaviour or deterring those who might otherwise flout legal obligations. Indeed, they expressly state that enforcement action may be appropriate, in particular, where A, breaches of the law point to systemic failures in the market, B, where changing the behaviour of one business would set a precedent or have other market-wide implications, C, where there's an opportunity to set an important legal precedent, or D, where there's a strong need for deterrence or to secure compensation for consumers. So aside from those general high-level principles, in my view, there are three key learnings from the document. First, the CMA has expressly stated that it is more likely to take civil rather than criminal action, though of course it does have powers in relation to both. In summary, they say that criminal prosecution is only likely to flow where this is likely to have an effect across the market or wider economy, i.e. where the public interest requires it. Perhaps not as great a comfort to businesses as might historically have been the case, given the possibility of exceptionally high civil financial penalties. Second, where civil action is to be taken, the CMA are more likely to use their direct enforcement powers rather than going through the courts. Express exceptions to this include where consumer legislation is not within the scope of the CMA's direct enforcement powers, such as the Estate Agents Act and the Misrepresentation Act, or where the CMA considers urgent action is required, so an interim enforcement order is necessary. It remains to be seen whether this will lead to a speedier process for all involved. And third, in a similar vein to the CMA's recent sector-specific guidance for consumers on veterinary services, green heating and insulation products, we can expect CMA publications providing advice, guidance and information for businesses and consumers alike. These are most likely to be expected after the CMA has completed a compliance review, market study or made a decision under its direct enforcement powers. It will therefore be important to keep an eye out on CMA publications to ensure any sector-specific guidance isn't missed. Well, what about concurrency? The CMA has expanded its remit into an area that has traditionally been primarily governed by trading standards. So thought has clearly been given to the delineation of responsibility to ensure consumer detriment doesn't inadvertently fall through the net. The CMA expressly recognised that trading standards enforce a far broader range of legislation than the CMA, having responsibility, for example, for animal health, food safety, underage sales, etc. And state, and I quote again, the focus of the CMA is on systemic, wide market issues, while trading standards tackles consumer detriment more generally. An example of work that clearly falls into the remit of trading standards is addressing local, regional and national detriment caused by rogue traders, including doorstep crime, and scams, using effective partnerships with local agencies and in-depth knowledge of local markets and businesses. Another example would be a case that involves a single large business, again whether at local, regional or national level, unless there are additional factors which make it suitable for the CMA in terms of, for instance, changing the working of the market as a whole or setting a legal precedent. That's the end of the quote. It remains to be seen how this delineation will work in practice, but the CMA flag a number of mechanisms to ensure consumer detriment is appropriately covered, including, first, a requirement for the CMA to be notified in advance of another enforcer applying for a consumer protection order. Second, the requirement for the CMA to be notified if an undertaking is accepted. And of course, both of those requirements aren't new, having been in place under the previous Enterprise Act regime. Thirdly, the requirement for trading standards to notify the CMA if they intend to commence a criminal prosecution of listed offences. Fourthly, the CMA flagged the various provisions in the DMCC that trading standards have the duty to enforce, in contrast to the CMA, which has such powers but no accompanying duty. So we may see a need by trading standards to keep an eye on the CMA's action to ensure that their duties are appropriately carried out. Fifthly, the CMA flagged the possibility of them choosing to bring a matter to the attention of another enforcer. And of course, that fulfills the CMA's responsibility under the DMCC to have regard to the desirability of encouraging control of unfair commercial practices by established means, as it considers appropriate, having regard to all the circumstances of the particular case. No doubt the new regime will take a little time to bed in, but how different enforcers, some of which are highly specialised, work together is clearly at the forefront of the CMA's mind.
Well, thank you, Sabrina. That concludes today's Gough Square Live. We'll, of course, revert in due course if there are any substantial amendments in the final documents, no doubt due to be published in the coming months. Thanks so much for joining, and do join us at the next session. It's from Sabrina Goodchild, goodbye.
And from Jack Brady, goodbye.